This is Showmitra Lahiri. We are talking about Guide to IBC.com. IBC.com deals with Insolvency and Bankruptcy Code, which is promulgated in India, and I hope this is being viewed basically in India. Now, as I had mentioned in my earlier video, that there are nearly about 2,000 odd topics and about 4,800 odd case extracts in the website. And our USP are topics. What are topics? When a case happens, there are headlines. So when similar headlines come together or something new comes, we develop a topic. It develops into a topic. And so that, all new things, one can understand the ambit or the focal length of the law or a particular section or a regulation as to how far it stretches. Now, a case need not be confined to one particular section or one particular regulation. It can consist of many things. But I'm not here to talk about all the cases and all the regulations. Let us not delve into that. But in order to make it interesting for you and so that you can keep a track, what we are going to talk are about cases which have happened very recently. So I am covering cases up to, say, last Friday. So whatever cases have taken place in 6-7 days before last Friday, and those which will have him, we are going to talk about those only. And here also I'm going to be brief, because you are in any case going to go through the cases. Right? So I'm going to be brief, but we'll try to give you as much possible idea as to what are. Now, how do you find the cases? Now, let me share the website. Now, let it come on screen. Yeah. You can see the screen, I suppose. Now, if you scroll down a bit, you will see there's a what's new. Now, it comes one after the other. There are about 10 odd judgments which come one after. Now, let us select any one of them. So we select Delhi Development. If you click on it, pop-up window comes, it shows section, topic number, regulation, topic. Now this way you come to the section and this shows you where you can find the case. As I said, this particular case that means this particular case will feature in section 35. In topic 27 it is there. We do not know what is topic 27 at this moment. And this is also in schedule 1 of liquidation, topic 49. Now let us look into what is topic 49. How do we go into it? We select Insolvency Bankruptcy Code, select Corporate Insolvency. Now, Corporate Insolvency, we come to Liquidation Regulations. Now, Liquidation Regulations, before you come in, how do you find out where is topic? Where is Schedule 1? See the View Index. If you go into View Index, it's a kind of a box, it's a table. We have tried to match sections and regulations, correlate them. As I had mentioned earlier, this may not be 100% accurate. But this is somewhat, this will make you, because in order to understand the law, you have to understand the structure. Reading the section and the regulation separately will make it much more complicated and difficult. Now, what we see, we go into section 35, we see schedule 1. Excellent. So let us go back to IB code. We select liquidation regulations. We come to 35, view regulations, and we go to schedule 1, view case laws. Now, what we have mentioned, topic 49. So what is topic 49? You can see that topic 49 says that one can only sell what he owns. What you do not own, you cannot sell that. What you own, you can sell that. What you do not own, you cannot sell that. The auction process cannot create any right title on the if the same does not exist ab initio. This particular case happened. This is the case IBC Development Authority versus SGT Towers Private Limited, civil appeal number 1972 of 2011. This came out on last Friday. It's an old case, but which was decided on last Friday. Now, in this particular thing, if we look at the headlines are quite, I have used much more headlines so that it makes one can look at the headline and understand. It so happened that one particular company had taken a property on lease from Delhi Development Authority, but the lease did not get executed. The company sold it to somebody. Now later on, that company went into liquidation and blah blah. They liquidated and the money was invested in bank, etc. But ultimately, what court said is that it was given to pure drinks, and court said is that look, there was no the person who has it now, the auction purchaser, doesn't have any right over the property because ab initio the lease was not executed, so there is no right. And it also said, let us go back. Let us go into section 35, topic 27. We come to yeah, 27 says, no, the stakeholder have no right to any part of the unearned income since the property was not constituent of the liquidation estate. You know, the liquidator had invested the funds in fixed deposit. The fixed deposit increased. Now, there were claims from others. Now, the question is, does it go to the stakeholders? No, because this was not itself a property in the liquidation estate. So, how can it be? So, once you go through the case, you will understand. I'm just giving you a flashback of the case. Now, we come to the second case. What is it? Kamal Kumar Harlalka. This is in Regulation 32A. Good. Regulation 35 in 35. What is 32A? Going concern sale. 32A, we have 32A. This is topic number 7. What is topic number 17? Post completion of going concern sale. It is the purchaser who has locus to pursue or continue with any related litigation. Prior to sale, it is only the liquidator pursuing liquidation or on behalf of the liquidator. Now the case is here. Kamal Kumar Harlalka. You can see the case. Now this was an application made by the CD. The promoter of the CD, he wanted to do this. The court said, no, sorry, you have no locus. It is since the property has been handed over to the purchaser, it is the purchaser who has the right, who holds the right custody and right and custody over the property. So if the case is to be handled, it has to be handled by him. And before the going concern sale takes place, it is the liquidator who has the right. Prior to that, it is the liquidator. In any case, post liquidation, the promoters have no right over they have no locus once the liquidation starts. Now let us switch over to adjudicating authority. If we come to corporate insolvency, go to adjudicating. Now we have one case. It is IMEX Services Limited versus Office of the Assistant Commissioner of Customs. This is in topic 92. So what is topic 92? Now how did we IMEX Services Limited, how did it come from? Let us go to make it easy. IMEX Security, we'll see IMEX Security here. So IMEX Security, I have covered cases for about last 2 weeks, I think, more than 10 cases. So IMEX Security was done really. So IMEX Security is, so if you go to topic 60, I mean section 60 and topic 90, 92, it says that adjudicating authority has no jurisdiction to enter into the issue regarding determining the liability of custom state. Now you cannot go to, this is sole domain. Insolvency Bankruptcy Code is solely concerned with insolvency and bankruptcy. Customs duty is altogether the domain of Customs Authority, which is again another quasi-judicial authority. So, Insolvency Bankruptcy Code, you cannot go to NCLT and say that, sorry, sir, you determine my customs liability. No, it is not the jurisdiction of the state. That's it. But that was this case. Now we come to a very important case. That is Rakesh Arora and another versus acute daily media private limited. This is 2024 case. This deals with section 65. Topic 22. So what does topic 22 say? No interpretation can be put on the provisions of section 65 that a penalty can be imposed on any other person except those who have initiated the insolvency resolution. No interpretation can be put on the provisions. How do you, this will need a little bit of, I presume, to make it easy. Let us go and see what is section 65. If any person initiates the insolvency, so it is concerning the person who has initiated. In section 65, you can deal with only if that person has done something malicious, has instituted CIP proceedings with malicious intent, other than insolvency of the company. But you cannot bring in someone else. You cannot say the promoter has done it or friends has been it. No. It's only pertaining to the person who has initiated the process. Other than that, it is not. So, this is a very interesting case. Section 65. This is topic 22. This is the case Rakesh Arora. Go through the case. I think you should go through this case. You will find it very interesting. The case was the intervener wanted promoters to be court to take actions against the promoter, but the court said no. It is only the person who has initiated the CIP proceedings. That's the applicant who can do it. Now let us come to the definition. Now this is again a Supreme Court case. 5A. This deals with financial debt. Financial debt, topic 26. What constitutes commercial effect of that? Now we know that in order to constitute financial debt, there has to be time, consideration for time value of money, and it has the borrowing itself must be, there has to be a commercial effect. So what did the Supreme Court find? This is the case where a service is availed for any commercial purpose. Then the person who has availed such services is not a consumer for the purposes of the act. When you, for commercial purposes, you have availed services, then you are not no longer a consumer. This was a case of consumer forum, consumer dispute. So, as per consumer dispute, redressal commission held that you are not a consumer. When a person uses goods bought and availed services for the sole purpose of earning his livelihood by means of self-employment, then such person is not excluded from the definition of consumer under the Act. The nature of the transaction, that is availing of credit facility from the appellant bank, which is purely a business-to-business transaction entered into for commercial. The commercial effect of borrowing, so going through this case will, though this is not concerning insolvency bankruptcy code, this will make you understand what is commercial effect of it. That's what is most important. Now we shift from definition, we come to another very important case, which is going to change a lot. That is Himanshu Singh versus HDFC Bank Limited. That's an NCLAT case that pertains to Section 12A and Regulation 30. 12A, Regulation 30A. We come to this is topic number 8. Now, this is a monumental shift. Before COC is constituted, NCLT must decide application after hearing all the parties concerned and considering all relevant factors on the facts of each case. In this particular case, this was a case constituted by this case demonstrating whether HDFC Bank Limited and another. In this particular case, the case was instituted by SIDBI, SIDBI, but HDFC Bank lodged a claim which was for 3 times of SIDBI. The last date for filing of HDFC had filed claim before the last date of filing of claims. But in the meanwhile, there was another settlement between the applicant, between the applicant and the CD. They had Form FA was submitted. HDFC took it to NCLAT. NCLAT said this took reference from Gilstrom's case. And it said that once insolvency is instituted, it's no more confined to 2 persons. That is applicant and the CD. It now constitutes, it becomes it is a plurality concept. It takes into concern all the stakeholders. So, since HDFC Bank had filed a claim, so NCLT should take its opinion before allowing the withdrawal. So, this is a monumental shift. And this hasn't come by way of a regulation. So, we have to keep this in mind. This is a very important judgment. Let us come to, let us go back to CIRT. There's another case. Now, under normal circumstances, you would say that why are we dealing with this? Because this is regulation, this is regulation 12. So, go to section 18, view regulation 12. Yes. Sri Krishan and another versus HS Oberoi Bimtech Private Limited and others. 2025 case, regulation 12, topic 11. What is topic 11? Topic 11 says that post-resolution plan being approved, there is no scope of creditors to file claim. Now, this is why it is important, this particular case. Sri Krishan and others. In this particular case, the case had happened that the resolution plan had been approved. The SRA had allowed people, those who had not filed claim, to come and lodge claim within 12 months of the passing of the resolution plan. But this gentleman came 27 months later. Now, then NCLAT said that, sorry, my dear, you have come 27 months later. Already SRA had extended this facility. Now, with considering Ghanshyam Mishra judgment, you can, SRA is not obliged to give you any benefit. And of course, a question, this is why this is important, because it concerns a homeowner. So that is why this is it. Now let us come to another judgment. This concerns section JK Paper Fiber Resources versus Sunil Jagdish Chandra Shah. This is also 2025 judgment. Now, let us go back to IB code. Section 12, topic 13. For the sake of resolution plan, if COC has approved extension of time, the same may be considered to have been granted even after 230 days. So, for the sake of, we know that in insolvency, resolution plan is the goal. Revival of the company is the main objective of Insolvency Bankruptcy Code. So maybe until COC has approved extension of resolution, extension of CIP period, somehow the NCLT could not take it up. In such case, NCLT is to assume, since COC had passed the resolution, COC is to consider that yes, there is ample grounds for resolution, even if 330 days are over. So it should be considered to have been given. Now, it also deals with section 30, topic 18. Let us go back, section topic 18. So what does topic 18 say? COC, through its commercial wisdom, has the right to reject or approve a resolution plan. The adjudicating authority can only screen whether the plan approved by COC is compliant to requirements of section 3, section 2 of the code. There are a number of cases. This is possibly the last one. GK paper 5. So, here the operational creditor had come and they had raised a question. Firstly, the ground was 330 days were over. So court said that, sorry, you were very much a part of the COC. You cannot say that you were ignorant. You did not know that the plan line has extended. COC had approved for extension, so it's not concerned. They had seen the evaluation report and considered section 53, waterfall mechanism. They found that the operational creditor was getting more money than what he was due. So they accepted it. And thirdly, I mean, they said that, sorry, it's beyond our purview because it's not justiciable. Commercial wisdom of COC is not justiciable. Now, this case also said two very important things, which you will find in uh, Regulation 35 concerning valuation. Fair value acquisition. Topic 13. It is the COC who are to exercise commercial wisdom and decide whether full valuation report is to be placed or just the fair value and liquidation value should be communicated. Now, COC in its commercial wisdom to decide RP is not required to do anything. Once the valuation is obtained, RP is to inform the COC. COC is to decide whether the entire valuation report is to be shared or detailed information should be shared, or it's just the fair value and market value which is to be shared. Second point it said was also very important. It's concerning Regulation 36A. Fractional creditor cannot rightfully claim that their interest was prejudicially affected due to non-publication of Form G. The court said that it is the persons who are, it is the resolution applicants who can say, who is an operational creditor to say their right is prejudicially affected. So you cannot raise an objection to NCLT or NCLAT or based on flimsy grounds. So this is a new topic which I thought will be of interest to you, and so this case was shared. There's another. Let us come to the next case. We are almost coming to the end of it. It's section 31 case. Sequences of not adhering to timelines in the resolution plan cannot be reversed after considerable lapse. In this case, the SRA did not pay up. So the court said, sorry, my dear, you have not paid within the time stipulated. But now you cannot go back and say that I'm willing to pay. The court allowed CIRP to pay refinance. But the SRA did not pay in time, so the court said, sorry, we are not going to. The consequences of not adhering to the timeline, it cannot be reversed. So, and another thing which court said, it's in Regulation 36B, topic 2, it says that performance guarantee can be invoked, which of course you know that if the resolution plan has not been implemented, the COC retains the right to invoke the performance guarantee. I'm not going into that. Let us switch over to the last case. This is a new topic, so you will be very much interested. This is a Supreme Court judgment, Sarega Anil Kumar Agarwal versus Bhavesh Dheeraj Seth and others. Civil appeal number 4048 of 2024. It concerns regulation, it concerns section 96. So we go to individual and firm 96 interim moratorium. Topic 12 says what? The moratorium under Section 96 does not cover penal proceedings or penalties which are regulatory. This is concerning deaths only. This is concerning deaths only. So, if, say, consumer court or any other court has imposed a imposed a penalty, that cannot be, that cannot be, that cannot be. I mean, nobody can take shield under section interim moratorium by saying that moratorium is there, so it is not. No, it is concerning that. It's also, the court did not specify very clearly proceedings under section 138 of Negotiable Instrument Act come within the ambit of moratorium 26, since assumption of debt is inherent in the offense itself. So when a check bounces, it is concerning debt. So 138 proceedings cannot be initiated if, as per this judgment, and which is as recent as of last week, cannot be initiated in such case. Of course, court, this is the judgment. You can have a look at it. Starring Anil Kumar, topic 13, so you can have a look. Case extracts are there. One more case I have not included in today's, but I think I'll cover that. That is in corporate insolvency, in personal guarantors. In insolvency, let us go to Rule 7, application by creditor. It says it is the case of State Bank of India versus Mr. Deepak Kumar Singhania. It says that invocation of personal guarantee must precede issuance of notice in Form B under Rule 7. Until and unless the personal guarantee is invoked, how can you raise a demand? And a demand, first the default has to take place. So this is a paramount shift. And this particular instance is going to have tremendous effect on the future cases. So this is a very important case. I would recommend the readers to go through this. Well, this is the, if you like it, please do click on the like button and subscribe to the channel. We'll possibly come again after a week or so, or after my practice, once we get some good judgments. Hope you liked it. All the best. Go through the website. We'll be thankful if it can help people to learn the website and love it the way I do. Thank you. Bye-bye.